All right, I call this meeting of the Planning Commission to order. First item on the agenda is the approval of tonight's agenda. Anybody have any questions or?
Excuse me, Matt, if I
Yeah.
may, just one typo in item number 1 for the public hearing.
Yes.
That tax map number actually should be 654-00-00001. It was correct on the actual agenda item within the packet, and the advertisement was correct. We just didn't fix it on the actual agenda item there.
Thank you.
know. Thank you.
Okay. We have a motion to accept the agenda?
A motion to accept the agenda?
All right, second?
A second.
All those in favor? All right, next item is adoption of the minutes from April 8th. I do have one item on rezoning 24-16, which was on Hands Mill Highway. I just want to make sure that in the last sentence that it says it's not at a major road intersection. And then I'd also like to add that there are no like businesses in the area. And that was stated in the discussion when we had that meeting last month. Does anybody have anything else? If not, we have a motion to accept the minutes.
I make a motion.
I'll second.
Discussion, all those in favor? John? John? All those in favor?
Yes, sorry.
Okay, first item on the agenda tonight is a public hearing. Chaplain Spencer has filed an administrative appeal to staff's decision to classify the division of tax map number, get that right. 654-00-00-001 as a major subdivision. The subject property is a 43-acre parcel located in the AGC District, Council District 1, Audette. Case number is A24-01. Now, as this is a public hearing, we're going to, the appellant will get to speak first, and then staff will get to speak next. So, please, just state your name and address for the record.
Thank you, Chaplain Spencer. I'm an attorney in Rock Hill, 916 Myrtle Drive, Rock Hill, South Carolina. I represent the property owner, New Old, and this is a simple case. The owner wants to subdivide 43 acres into 2 lots, and I'm going to hand a couple of aerials so you can. These aerials kind of get you a picture of where we're talking about. This property is adjacent to Baxter. Baxter is one of the most densely populated residential single-family in the county. And the county has their response, but they really fail to consider the legal ramifications of illegal non-conforming rights. And they also fail to really consider their prior written determinations. The proposed plat is not increasing or intensifying any use. In fact, if you look on page 16 and 17 of your packet, there's a plat. It's a recorded plat. It's of the subject property. And there are at least 3 lots and arguably 6 lots with that. It was recorded under the county's it's really before they started regulating subdivisions, but it's recorded and it separates this property into separate parcels. The proposed recombination plat is only seeking 2 lots, and it's because of the limitations of an access easement. And I'm going to talk about that in greater detail in just a second. But as noted in the planner report, the AGC zoning, it allows 2 principal dwellings already on this property. And there's a lot of discussion about taxes in the report. I really don't understand how that's relevant, because they're like, well, it's taxed as one parcel, therefore it's one parcel. But there's a lot of subdivisions that are out there that haven't been developed. The taxing is only after there's a deed that separates the parcel from the master, and then they begin to tax it separately. But the prior owner obtained an access easement in 2009 from Clear Springs, and that was the developer of Baxter. That is on page 38 of your packet. The easement is 18 feet wide, which complied with the 2009 zoning code, and that's important. It can only be used for residential purposes, and under paragraph 8, you can only have 2 lots. So this access easement limits the use to 2 lots. Before purchasing the property, Troy Lubman with New Old, he confirmed with the county that the access easement was valid. He sent this access easement over there, had discussions, and if you look on page 46 of your packet, his email says, I want to confirm our discussion that even though the new regulations say 18 feet wide, I mean, even though the access easement has 18, we don't have to have the 25-foot wide access. Page 47, she responds, given that the 18-foot easement is existing, it's legal non-conforming. It can be utilized for the purpose outlined in the access agreement pertaining to the easement. It is legal non-conforming. This interpretation was right in August of 2022, and it's right now. So I'm going to hit a little law, which may be boring, but I think it's important for you to understand the non-conforming use. And the citation is Boom v. Town of Sullivan's Island, 813 Southeastern 2nd, 874. And this is a 2018 South Carolina Court of Appeals decision. Non-conforming use and vested right refer to the same concept, a use of property that existed lawfully before the enactment of zoning ordinance may continue afterwards, even though the use does not comply with the zoning restriction. The substantial value of property lies in its use. If the right to use is denied, the value of the property is annihilated, and ownership is rendered a barren right. A landowner acquires a vested right and continue a non-conforming use already in existence at the time the property is zoned, in absence of showing that the continuance of the use would constitute a detriment to public health, safety, or welfare. You've got 2 lots that are going to be subdivided or sought to be subdivided on 43 acres. Certainly a subdivision of that size for residential use is not a detriment to public health or safety. The 18-foot wide access easement was and continues to be used for access. It's not as wide as would be required today. It was non-conforming then. It's non-conforming now, but it's legal non-conforming. As noted earlier, the AGC zoning allows for 2 residences. Same thing would apply if this is subdivided, because paragraph 8 of that access easement limits the use in the subdivision to 2 lots. The legal non-conforming width should continue in the county. Previously agreed to that. It's the legal nonconformity that allows the continued use, the vested rights, and that was based upon the case law cited earlier. The county changed their position, and it's just wrong. If you look at the background memo, they also state that, well, there was discussion between the 18-foot width and the 25-foot width, and the full email was not included. Well, if you look at the full email, it provides even more. On page 53 of your packet is the original email that states that it is legal non-conforming, therefore it can continue. At the bottom of page 52 then asks, well, what if I want to do more with this? What if I want to do 6 lots? And that is where the response at the top of page 52, to do more than what the easement agreement states, that's the 2 lots, we would need a 25-foot easement. We're not asking to do more. We're asking to do the same. 2 lots on 43 acres. It's also, it was mentioned in the staff report that, well, the August decision from 2022 was not appealed. What was appealed was the February decision. Well, if you look at all the pages, it's just a 2-page letter. It's the same county employee making the same decision, actually a different decision. In August, they said it was legal non-conforming. And then in February of 2024, they said you can't do it. Nothing's changed. There's been no changes in the zoning code. The county should stand by its decision, and it's really stopped from changing its mind at this time. I'm going to quote another case, and this one's on estoppel. To prove estoppel against the government, the relying party must prove the lack of knowledge and the means of knowledge of the truth as to the facts in question, justifiable reliance upon the government's conduct, and the third element is a prejudicial change in position. That's from Grant versus City of Folly Beach, 551 Southeastern 2nd 229, and that's a 2001 case. Here, Newell really couldn't understand or expect the county to change its position after a written email confirmation. The reliance, it was reasonable. They met with them, sent the access easement, followed up with a writing, and got a confirmation. They got the confirmation, and if you look at the emails that I previously quoted on that, they're saying, we were planning on closing on this property. Before we close on the property, we want to make sure we can have access and use the property as contemplated in the access agreement. They got the written confirmation in August. Less than a month later, they closed on the property. The deed is included in the packet and has the bait stamp from the clerk of court recording, but it's September 6th. The legal nonconformity is what allows the plat approval. It's originally confirmed by the county planners, especially after Newell purchases property in such reliance. We just request that this planning commission overturn the denial and allow the approval of subdivision plat to allow 2 lots on 43 acres. In fact, I think the county should be supporting this type of limited use in this area. Should be jumping for joy that somebody wants to put 2 estate lots on 43 acres in this densely populated area that has all the traffic concerns. It's preserving land. And I'll be happy to answer any questions.
Anybody have any questions at this time? If not, the next staff would come present.
Let me just real quick, I'm sorry,
Sure.
I apologize for being a little bit delayed, if you don't mind, sir. So I was a little bit lost during the presentation because we have 2 sets of numbers in our packet. I'm sorry, that's right. Yep, get back to the mic. My apologies. Okay, so we've got 2 different sets of numbers in our packet. And so when you were referring to a page number, we have a comprehensive page number for everything we're doing tonight. So I was
Right.
a little bit behind what you were doing.
It
I
confused
think I've
me as
got
well.
that
It confused
figured out
me too,
now.
because I switched the way I did it.
Yeah.
I originally had, it is following this case packet number, which has, I think, 62 pages.
Yes, I've got that cleared up
And
now.
that follows what
So I would
staff
like
did.
to go back, if you wouldn't mind, real quick, just to make sure I'm clear. So it starts on page 53 of the 62, which is 69 of our total packet. And there's an email that says, given the 18-foot easement existing, it's legal nonconforming. It can be utilized as for the purposes outlined in the access agreement, okay? And then the response is, okay, so if I'm able to change it and do 6 lots, then it would need to be adjusted to 25. And
Absolutely.
and there's a confirmation back that says, yes, if you do anything to change how it is today, you would need to go to 25. Am I understanding that correctly?
Yeah, if you want to use the access easement for more than 2 lots, because the access easement allows 2 lots. So you're saying if I'm going to subdivide it into 6 lots, you would have to then, your nonconformity vanishes then.
Right.
Yes.
So the argument is that the nonconformity is still tied to the fact that there are 2 lots.
Yes, and it was stated you could use it for the 2 lots because the current zoning code, including under the AGC zoning, allows 2 principal residences on the lot.
2, okay. And,
But yes, that is correct.
okay, thank you.
And if we do more than that, we've gone beyond the access easement and the written
Okay,
confirmation.
thank you very much.
Okay.
Okay, staff will now come present.
Thank you. Let's see if you can hear me here, if this works. Apologize for the confusing on the extra numbers. We had quite a large attachment. I'm making a staff report. We didn't have this packet made, so I didn't know where things would land. Let's try to help you navigate that.
Could you just state your name for the record? So,
Rick Aboud, the principal planner for
Thanks.
York County. And you talked to the owner or the applicant here, Mr. Chaplain Spencer. There's about the 25-foot wide access easement. This is a vicinity map. Like you said, you got Baxter on the west and TK on the east. I kind of got an appeal summary, and you have the packet application in there, and they talked about the problem with us denying the plat for not having a 25-foot wide easement. And they talked about a recombination plat, maybe accessed with a non-conforming easement. And then written confirmation was provided that the non-conforming access would allow subdivision. A 25-foot access requirement from Chapter C doesn't apply when the total number of lots is not increased. And just kind of a brief summary of that. You'll see in the packet more explanation. But there's no recombination of the lots indicated in any of the submittal documents verified with any deed or any parcel ID numbers assigned by the county or anything. I'll go into that a little bit deeper on another slide. Communications with staff are not subject to the appeal of the administration decision and did not state that an easement was adequate for subdivision. I'm kind of curious how we can make rules about subdivision or anything else in an easement document. That's a third-party document that's not part of the county's purview. We never reviewed that. You guys didn't look at that. In their paragraph 8, it says you may subdivide it according to the use of that easement. They said it's okay if you subdivide 2 lots or have 2 houses on there. And then take a look at this. And you have it in your packet. You get this view. You're not going to be able to read all this, but this is the original boundary survey that went with the transfer of the property. And you will see this is 1 lot, 1 tax number, no lines indicating anything else. You have a registered surveyor and engineering company that did this. Then again, on their submittal for the actual subdivision itself, again, you will see no little lines. It says there's a recombination of any sort going on here. And so that kind of goes to the fact that this has always been known as 1 lot. You did mention the page. There's a colored picture of this, but this is a recorded document from '76. I'm not sure of everything that was going on in '76, but you will notice that there are no pins or markers for any of the subdivisions in here. It does say it's a boundary survey. It's not a plat. You know, we don't do platting with boundary surveys. It is recorded, but there's no county acknowledgement of this at all. You know, we're here for the appeal of administrative decision. You know, and that decision is to deny the plat as with the access easement that was provided. Again, this is, you know, a determination that was made by staff and official act. And the one problem we have, we can't, you know, do this is because zoning code and the code's quoted in your handout, that we can't create a non-conforming lot. Now, certainly we have a legal non-conforming lot. It can certainly go in perpetuity to be used like it is now. You know, the access is non-conforming, but when you create two lots, now you've created another non-conforming lot that has non-conforming access. So they could continue, you know, a non-conformity can continue in its current state, but you generally can't increase a non-conformity. And the one thing, you know, he mentioned, you know, this might not be so bad of an idea to use, but he's not exhausted all his due process for relief. He needs to ask you for a waiver and fill out an application. We provided one online, and come before you because you're the only one that can permit a deviation from the land use code, development code. So we would suggest that he do that. And like I said, I just don't see an easement, access easement granting rights for subdivision, and we just didn't have the authority to grant this. We do not believe the evidence is presented for the requirement of to go beyond, you know, to do something different than a 25-foot access easement. I don't see any grounds to deny or to overturn the denial of the permit. And they're encouraged to submit an application for a waiver, and then we could just talk about the density and use of the 18-foot easement, and you can grant them the authority to do that. Mr. Buck.
I've got a question. Can you go back a couple maps? There, right there.
Yeah.
So you got track A and track B, but lots, you only had one. Is that right?
Excuse me?
On this, it says tract A,
Yeah.
track B. So, but it's on one lot.
Exactly, yeah.
Is
They're
that what you're
proposed-
saying?
Yeah, that is one lot, and they're proposing to divide it into the two tracks.
Okay.
This is what their document, you know, before, without any approval, the one right before it is a
Oh,
boundary
okay.
survey that would show you what they're dealing with right now.
Okay. So,
Go forward one more slide, sir.
We need to-
Nope, yep, so.
Yeah.
that's 24.
That's the one that was just submitted.
And then, yeah, the access up in the corner is the 18, and they got 20 through, that's fine once they cross the property line. That's not a problem, but it's getting to the lot.
So is the county's position that it was never subdivided into two lots, as the appellant is saying? Is that what?
No, it hasn't been. I don't see any evidence that it has. I mean, we talked about tax IDs, there's no deed, there's no pins in the boundary survey that show that anybody said anything. They recorded
So there's no
that.
record of that in the county
No, you don't
documents?
see anything that was submitted that shows any record of that other than the boundary survey that doesn't have any pins or any evidence that they've ever acted on that. So.
Okay, thank you.
Is there any other questions for Rick?
Just
Sure.
real quick.
Go ahead.
You mentioned something about a waiver. Can you tell us some more about what that would entail?
There's an application, so when there would be a hardship. So here, request for waiver of the requirements, but this is the 15400E2, which is a 25-foot access requirement, can be presented to the Planning Commission with strict application of provisions of Land Development Code result in a necessary hardship. I think this is what this is made for. And we would like them to do that.
So the recommendation from staff is to deny the appeal, but recommend that a waiver process be instituted instead?
Exactly.
Okay.
Yeah, that's why you need to apply.
Okay.
Like I said, we really didn't have, our hands are pretty tied on granting
Okay.
this. So.
Thank you.
Anybody?
The way, in 2022, when you had the 43 acre, the only lot, whatever, did it have it where you can build 2 residences on that 43 acres or what?
by code, you can have two principal dwellings, and the easement says that they can use the easement for that purpose, that use. So they can do that. It's just when they subdivide it, then you create another non-conforming lot that we would, you'd have to ask you for permission.
Okay.
Is there any other questions for Rick? If not, the next step would be the rebuttal from the applicant.
Thank you, and I'll keep it brief. This isn't about a third-party document trying to modify the zoning code. It's about an interpretation that was made, confirmed in writing numerous times. It's legal non-conforming. That decision was made in August of 2022. Nothing has changed. That written determination also didn't mention getting a waiver. If it had mentioned getting a waiver, perhaps there would have been a delay on purchasing the property. It said it is legal non-conforming. You can do this in accordance with the access easement. There's also discussion of the boundary survey. Well, the boundary survey is not recorded. That was for a quitclaim deed. If you look at the limited warranty deed that's in your packet, it refers back to the 1976 plat. The 1976 plat is the only document of record, and it subdivides the property. And there are calls. If you look, that's on pages 17 and 18, there are lengths. You have to squint a little bit, but there are lengths that you could get a legal description to divide that parcel. In fact, it says parcel A, B, and C. And I get we can file for a waiver, but we had to file the appeal within 30 days or our rights are lost. And I think that we are entitled to the appeal. I love the waiver, but it puts it in your hands, and if I'm right legally, I'm right legally. So we had to file the appeal or our rights are lost. The waiver can be filed later, but they're separate issues. And we believe we're right on this one, and we believe that you should overturn planning staff for that reason.
Okay, so let me ask you one question. So I understand what's shown on the 1976 plat. How come that was not reflected on the boundary that was done recently, on the boundary survey? If these were lots of record that are subdivided, wouldn't he be required to show those?
No, you can do a new plat, and he's not required to do it. You can submit a new plat, but the boundary survey was just to get a quitclaim deed for a lot of this property, especially that's years old out in the country. You'll have one survey, and it'll say it's 43 acres, and then you get somebody out in the field, and it'll end up being 44, 45. The acreage changes, but every deed still refers back to that 1976 recorded plat.
Yeah, I understand that, but if there were multiple parcels on that, wouldn't he show that as a part of his survey? Because that's part of the land then. If those are truly lots, he would be required to show them. I don't know of a surveyor that would not show lots that are.
Oh, because they haven't been deeded out. But I don't think that's the key to the issue. We've got 3 or 6, however many lots you look at from 1976, but we're not trying to do that. We're trying to subdivide into 2 lots in accordance with the access agreement. And we're informed that that was legal non-conforming because you could already use it for 2 lots. In the AGC zoning, the width of the easement is already established. It's already there at 18 feet. So it says you can still do this. And that was the determination in those emails. And that's what we relied upon. I was just showing what the 1976 plat, it was subdivided. And if they did a legal description and started deeding out from those, then you would definitely have to show it of record with anything else.
So the easement agreement that states it can be subdivided into 2 lots.
Correct.
But
No
that's
more than
not
2.
a guarantee it can be subdivided into 2 lots.
No, but that's why we asked the county for an interpretation, and the county planner, the same one that made the determination in February, said yes, it is a legal non-conforming. It's 18 feet wide now. We would require it to be wider now, but it's 18 feet wide now. You can use it for access as contemplated in the access agreement, which is 2 lots. But if you go up above 2 lots, then you're gonna have to have a 25-foot access easement. Because the use doesn't change. You can have 2 residences on it now in AGC. You can have 2 residences and no more than 2 under the access agreement because they cap it. So it's the same use.
So I think that, in my opinion, or what
Yes.
I've read, the access agreement actually speaks to the fact that it was viewed and has always been viewed as one lot. That it was not previously subdivided, because then they would have talked about multiple existing lots, which lot could be no more than 2. You know, if there were 2, 3, 6, and the easement agreement said that it could be divided into no more than 2 lots, doesn't make sense to me that they would have thought it was already more than 1 lot.
This is the public hearing section. We aren't having comments back and forth, but just let you know with that, please.
Yeah, this is, right now it's questions for
Yeah.
the appellant.
Well, I guess that's getting to
Ask
the
him a
question
question.
a long way around. Is there any documentation when Springs sold it to Mr. Rose, initially in 2009, outside of just the verbiage in the agreement?
No, and if you look
Do
at
we
the
have
agreement,
that?
there's, let's look at page
38.
38. 36 has a depiction. It shows it, and it actually, in the easement agreement, it looks like it's contemplating multiple lots, because I think it even says it's 50 acres. Find that right quick.
I believe you're on page 31 of the 62, at the bottom of the second major paragraph on
Yep,
that page.
that is it.
Is your 50 acres.
Yep.
But the,
So this was always contemplating too. And
yeah,
it
I'm
was,
looking
and
at
it was,
page-
it
I'm
was
looking at
legal
page
and non.
38 on 62, of 62. That's where it
The
has
access
the-
easement's in there twice. Which,
That appears to be the same document.
it's the same doc. See, that may be confusing people too, because
Okay, yeah. The
So, I'm sorry,
document's in
point
there.
out again what you were saying.
this contemplated, it always contemplated 2 lots, the access agreement. And the access agreement was presented to planning staff, and it was 18 feet wide at the time, 2009, and it was legal. Legal nonconforming means you get to continue that. And they said, can we still use this for the intended purpose? Planning staff said, absolutely.
I guess my question is, again, show me where it is already 2 lots.
Where's that?
Now, can I say something? Point 8 says, this easement is made up of express condition that dominant tract shall contain not more than 2 single-family residential dwellings. It doesn't say anything about lots there.
It's further down in that
Yeah,
paragraph.
it does say 2 lots or parcels.
Where is that, Mike?
Same
Same paragraph. That same section. Read the last
Same
couple
section further
sentences.
down.
No, you're going too far.
Oh, okay.
So I think it appears that in this easement agreement, there was a statement that the easement would remain in effect so long as the property was not divided more than 2 lots.
That's
But
how I
there's,
read it, yeah.
but there's nothing that says the property actually existed as 2 lots.
I, in fact,
Right.
read it well, so we can't speak, I mean, can we have this discussion right now, or?
I think you can probably wait for the discussion to a little bit later, once you hear the public hearing first. If you have a
Okay.
question, that's one thing, but to have a conversation, it's best to have that outside of the public
Okay.
hearing.
I do have a couple of questions, Mr. Spencer.
Mike can, the access easement says 50 acres. And it references this plat, the 1976 plat. If you look, there's a 42.56 acre parcel, the big one, parcel B, and then parcel A is the other parcel. And it's about 7.5 acres. But that's how there were multiple lots.
Okay.
So, okay, then going back to the parcel number that we're talking about right now, what is that acreage? Isn't it 42 and change?
It is.
So it does not include that second parcel that you're saying is included.
No, there was the access easement, I think it made an error and thought those were 2 lots. They thought that the 7 acres was in addition to the 42.556, but it's included in it.
So it would just be 1 lot.
No, that's parcel A. If you look there, it's parcel A, parcel B, and parcel C.
Yes.
And that's the only recorded plat we have from the county. It's parcel A, parcel B, and parcel C.
And we're calling B and C those triangles essentially on the side of, or are we calling that B?
B would be the triangle. Parcel A is the rectangle.
Yeah.
Then there's another triangle down below. And I think the color, yeah, it's not on there. There's a color one in the packet.
No, yeah, I have seen the color one in the packet. Okay.
So has there been any deed or any document that's been recorded that describes these parcels?
Yes, the deed that is in your.
It mentions parcels A, B, and C.
No, it mentions the plat.
Okay.
The legal description references the plat. And if you look, Exhibit B is the legal description, and that is on page 27. And at the that's the fee parcel. The
Okay.
limited warranty deed starts on page 19. And the legal description is on page 27. And if you look at the bottom of that first big paragraph, it's more specifically shown on the platted boundary survey of J.W. Sutton, property dated August 1976. And then it talks about where it's recorded in plat book 50, page 111.
Is there any title search that was done that confirms this is also clear? These are multiple parcels besides just references to the plat?
The plat's a subdivision.
So one of
But
the,
that's one issue, but the other issue is the county planner said that this was a legal non-conforming use and it could continue and it could be subdivided as contemplated in the access easement, which is under paragraph 8, 2 lots. No more than 2 lots.
so if this was a separate parcel already, and I know one of the comments was that it's always been taxed as one parcel.
Okay, if Baxter was to subdivide and create 500 lots, they have their subdivision plat, they got 400 lots, they do not create 400 tax parcels right at the beginning. That would be a nightmare for your treasurer. If they wait until there's a deed, and the deed says parcel 28 from the plat recorded in plat book 12, page 67 recorded on this date, and then once that goes out the first time, then that parcel gets a number, tax parcel number.
I mean, so if you have a parcel, then would you not want to draft a deed to describe it, and then you could get a tax map number off of it?
When you're ready to develop and move it out, yes. But until that time, it's probably better to have it under one tax parcel, and your taxes are probably cheaper. But there's no need to have a different tax parcel because it's under the same ownership.
So I guess we go back to how can someone look at this other than just saying the 1976 plat shows parcels A, B, and C? How is it a subdivision?
Because I can take the meets and bounds, that parcel A, you can see at the bottom where it goes through and it tells you the length, how long it is, and then it's got the degrees.
Okay.
You can draft that into a legal description.
So if they were parcels, why wasn't it shown in the 2022 survey?
It wasn't recorded. That was a boundary survey to get a quitclaim deed.
But if those were parcels, I would still think that you would want them to be shown.
It gives
Because
you,
they're part of the record, correct? Just like it's, it's along the creeks and
yeah, but the intent was to do a recombination and do a new survey with just 2 lots because they can't have that many lots to be in compliance with their access easement.
I understand that.
Ask
Go
a
ahead, yeah,
question?
feel free to ask a question.
So, I'm adding things up here. So, this map that we're looking at right here, 42.556 acres, and then you got parcel A. So, on the map that was done in February of '24, it has 42 total acres, not 50.
Correct. Correct.
So, is that where the second, I'm just asking a question, is that where the
If we were
two
to,
parcels
if we were to
came up, or
record,
what?
if we were to move to try to subdivide and use more than 2 lots, we would be in violation of the access easement, paragraph 8. It says they can void it if you try to move for more than 2 lots. So we're not trying to do that. That's why we never wanted to move forward. That's why we're trying to recombine and only create 2 lots. The whole purpose of showing you the 1976 easement is to demonstrate we're not creating more intense use. Legal nonconforming, you can't increase the intensity. It's going down. And it's also the same as currently allowed in the current zoning ordinance, where you can have 2 residences on an AGC lot.
It's like you're moving tract A or parcel A from where it is there to over to the right.
Yeah, we're just
Is that the
realigning it
question?
with the topography. Let's see.
But I'm confused because wouldn't the description, the original description follow the old, the one you had on it first? Wouldn't the description follow that right there for parcel A?
That is how we got our legal description for the deed, referencing that plat. But then when we wanted a new subdivision plat, you just create a plat through meets and bounds. You get another, because the lot lines are going to move anyway.
I guess my question is, does it change the way it's, I mean, if they change where parcel A is? I'm just asking that
The new
question.
plat would supersede the old one.
What's that?
A new plat a new recorded plat would supersede the old one once it's recorded and on record. But we can't do a new plat with multiple lots and try to use that access easement because we're limited to 2 on 43 acres. It gets,
If
I think it
this
gets back to me is planning staff looked at this in August of 2022 and said, yes, you can still do this. You're legal non-conforming. You are legal non-conforming. You can subdivide it as contemplated in the access easement. You can divide it. You can do that. Nothing has changed. And here we are on an application made in February 2022, same staff member. They said, no, you have to have a 25-foot easement. The nonconformity is the 18-foot width that would not be allowed now. So it's continuing on.
Diane, correct me,
Mm-hmm,
the new code was effective March 1st, 2022?
correct.
So in February of '22, if this had been a subdivision plat, I hate to throw out theoretical like this, what would have been the approval process? It would present the plat for 2 lots, utilizing the access easement.
Sure, I'll speak to it if I'm wrong, Marion, please interject. But if they had come in, I think, Dan, at 18 feet, they would have been okay to subdivide off of an 18-foot easement? Is that, or is, that's correct at that point? And then, and we could establish for 25 feet to have a lot more
Yes.
space for vehicles to get through there? Just want to add that, well, we'll leave it at that.
Yeah, so if anybody has any other questions for Mr. Spencer, this would be the time. If not, we'll move on to the public hearing portion. So if anybody is here to speak in favor, please step forward.
You need to ask them since
If it's part of the public hearing, you can absolutely speak at this point.
Hi, my name's Troy Ludeman. I just want to clarify a few things. This plat that's been on record with the county, you go to the GIS and click plat, that's been there for almost 46 years or 48 years, my math, on record. The easement that was entered into 2009, the easement agreement, references 50 acres because the assumption made looking at this map is that the large tract, they didn't go and resurvey this, there's no new survey. They assumed that that was 42 and a half, and the other parcel A, which measures out 7.5 acres.
But they,
So that agreement was acknowledging that there was 2 lots already. And I think that was the math that everybody was having some difficulty understanding. And the property has been developed. We have already cleared the roadways, or the private drive, excuse me, to access this parcel in the back. Let's see here. So we have already put that in. We put in a wooden bridge to access it, all permits in hand, septic, well, et cetera. And we had a buyer and have a buyer ready to purchase this lot, and we had only purchased this property with that assumption that we were doing it, or we never would have spared that expense. I think I did everything I could as a purchaser, verifying the codes, et cetera, following up with discussions, making sure it was clear before I purchased. And I think you can see from those emails, the response was clear. You can do 2 lots. And the only reason we didn't submit a new survey showing all those lots is because if we would have submitted that survey, we'd have been in violation of the easement agreement. And when we're in violation of that agreement, it's removed. Plain and simple. It's a very narrow path to navigate, not this property, but buying the property and putting it in 2 lots. and we had to make sure we did everything correctly, which I believe we did. Thank you.
Thank you. Anybody else that would like to speak? If no one else cares to speak, we can close the public hearing portion. Is there a motion to close?
I motion to close the public hearing.
Is there a second?
Second.
All right, all those in favor of closing the public hearing here? All right, at this point, staff would have one last opportunity. If there's any other statements you'd like to make?
Yeah, it's pretty easy, simple. I really don't have much to add. It's just one lot, you want to create two. We're not allowed to offer that option. And the easement document is not a grant of land use rights that the county had gave them. It's an agreement between two private landowners.
Just want to add one thing as well, that the, an email is not an official zoning determination. It's an email. So you can't really appeal an email. You appeal the determination. In this case, the determination was the denial from a submitted plat. That's what you appeal, not there was no determination from an email.
I just have one other question, not directly related to this, but is any counsel going to be here tonight?
I thought so.
And the applicant can get a waiver still, right?
Yes, and we recommend that process,
Okay.
and we would likely support that process as well.
I have a couple other questions, but I'm not sure where they go, so I'll throw them out. We'll see what happens. So who is the owner of the piece of property where the easement is currently?
Mr. Ludeman, I believe you own?
Baxter Community Association.
Okay.
Okay, and is a little bit hard to see from some of the aerials, but has there been any discussion with them about expanding the easement to 25?
There was initially when I went to, before I.
I'm sorry, if you could, for the record, no, if you could just come to the microphone so everyone can hear you.
No,
Oh.
correct. The only Mr. Spencer can speak.
Only Mr. Spencer can speak at this point. Okay, sorry.
He's the appellant.
Understood. Okay.
There were attempts made, tried to get it widened, and they were not interested. The easement they executed was in 2009, and they said, you got what you got.
Okay. So are you aware of any obstructions near that would prevent it from happening? That something's changed about the property that would make the extra 8 feet some kind of hardship on the property owner that granted the easement?
On the property owner, no, I don't think they want to grant it. I think they want this as preserved common open space. They want this undeveloped.
Okay.
I mean, that's what I think. They're like, well, if we aren't going to grant this, maybe it doesn't get developed. And we've got woods in our backyards, and a lot of people love woods in their backyard. I do too, but I think 2 lots on 43 acres is pretty special too.
So
But we've tried.
now, if I've heard you correctly, their concern was once it goes to 25 feet, maybe you get out of the easement agreement that's in place that would limit it to a maximum of 2 lots. More development may happen, and that was the concern.
Yeah, I think they're concerned there's
Okay.
going to be 6 lots.
Okay,
They-
thank you.
Yep.
That wasn't clear in what we had. Okay.
Good question. Feel free.
No, it's a good question. I thought that was a good question.
I guess this for staff, I have a question. Has there been any previous staff interpretation or that may be relevant, or anything regarding access easements or non-conforming uses that might apply, that,
Not that I'm aware of.
okay.
To tag onto that, are you aware of any other type of third-party easement agreements like this that you all have run across? I know that's a,
Marion, you know
that's-
that more than I do.
right? Okay,
Very unusual.
all right, thank you.
Does anybody have any other questions for the appellant or for staff?
I guess I just still am focused on the numbers, and maybe I shouldn't be, but how do we go from 50 acres to 42 and change if we have one, or if we have one lot?
Yeah, I think that was based on an interpretation,
yeah,
and
so the
misunderstanding.
access
That's
agreement
just a
says-
misunderstanding.
Yes,
The
just
access-
a math error, nothing more than
I
that.
think my opinion is that the access agreement where it says it grants a tract of 50 acres more or less, and it more fully described in the exhibit, and that's the
That's the-
specifics.
Yes.
Whatever that, I think whatever's in that exhibit is. Would you disagree?
That's correct.
Okay.
There was just 1976 plat and confusion. But
Understood.
it's 43 acres.
I do want to make a comment to that. If there is a meets and bounds legal description, it should say the 42 or whatever. It would have to add up to that. I mean, the surveyor would, they have to be correct on that.
Correct.
Yeah.
I don't think it was as important to have the calculation right for the grant of the easement. But if you're ever going to use the property, it can't go beyond that reference to the 1976 plat, because that has the legal description on it, the meets and bounds. So it can't go beyond that. So even if they said it was 50 acres, they're limited to the 43.
I'm not a surveyor, and I'm not gonna make anything, but I believe the level of accuracy that they were required to provide back in 76 is much different than it is today.
Oh, yeah.
Mostly due to the technology.
That was way pre-GPS.
If there's no more questions, would someone care to make a motion?
I think personally, looking at this and reading through this packet a couple of times this last week, that I believe this to be one property. And I read the easement agreement, even though it's not a binding county document, to say that you can subdivide it up to 2 pieces, but
I think
but
we
that's
need a,
not.
we
I
need a
mean,
motion before discussion.
I know, but I'm just trying to think how I want to. Sorry, I think out loud, and that's the problem.
I don't want to take away from your discussion. I just
Correct.
want you to
I'm
do,
not trying to-
let's get a motion
I think-
and then we'll have a
Okay,
discussion.
so my motion actually then is to uphold the county's decision, even though I do understand, it actually gets a little confusing when you talk, okay, so my motion is to uphold the county's decision.
All right, so I'm going to second that motion and then I'm going to send it back to you to make your comments.
So we have a motion and a second, so now we can have a discussion.
And yeah, tell me if you feel like I'm interpreting this incorrectly. And it is absolutely frustrating if you feel like you've gotten one answer and then it comes back as another. But as I am interpreting this, this is one property, one parcel. Because, and I understand with the subdivisions that typically individual lots are taxed after they have been recorded. So then my question becomes, why would there have been a different plat showing different, parcels if they had not already been subdivided? And when they came back in '09 and made this easement agreement, they thought, or it seems to be that they implied, that there was one large piece of property back there, not 6.
That goes to my question, why 2022, why they moved track A from
One location.
one location to the other. That's the reason why I was asking that question.
Gotcha.
Yeah, I agree with you.
And while I do understand that it says it can be divided, I feel like I feel like staff's decision is correct.
I really understand everyone's position on both sides of this. It is difficult, and I never like to be one to say to folks, well, you can't do what you want to do with your property, right? Within the bounds of the regulations that we have. And there's a lot of time and thought that went into those, but that notwithstanding, not to put restrictions on what people want to do with their property. I wouldn't want it done to me. The issue we have is we've got a very technical, specific situation where there appeared to be a green light, then the red light showed up, and then I think some panic set in about how do we respond to that and how do we explain to everyone what the intention was. And then during that process, other options may or may not have been made clear. So understand the time limit about making an appeal, but I don't remember seeing anything in the packet about a waiver until we showed up this evening. Now, maybe I missed that in the documentation because there was a lot to go through here, right? But as one of the options being a waiver, I'm not sure how well that was communicated to all parties involved. So there may be some other ways to solve this, but just the facts of what we have, there's one tax map, there's one parcel, and if you're gonna go beyond that, the code requires this, and all of that was changed prior to the property being purchased as part of recode and should have all come out. I think we have some miscommunication, and I think eventually we can probably get to what the landowner wants, but I'm not sure this is the process and the way to do it.
I agree.
Well, to answer your question about waiver, in staff response to appellate request number 4, says the appellant may request a waiver from the planning commission to seek relief from the minimum required
Okay,
access.
and right, with 79 pages, if that had been bold, underlined, I probably
No,
would
I
have caught that,
understand.
right?
It may not have jumped out, but
It didn't really jump out at me, right, and that, I guess that's,
I'm for you,
that's
yeah.
part of what I'm saying in how we communicate with each other, because if you have to read a paragraph 4 times to understand what the person was telling you, then, and I'm not trying to disparage anybody, I've had the same problem in my professional life with emails I receive from other people, and I've had to pick up the phone and say, what did you really mean? Because I just read that paragraph 3 times and I still don't know what you're asking me to do. So I'm just trying to point out that sometimes these miscommunications happen. Again, I think it's in everyone's best interest to work towards this so that this gentleman can have the 2 pieces that he thought he had, but that we find the process that's the appropriate way to get there and the staff work with him to get to that point versus what we've had before us tonight.
before we vote, I would like to make a motion to go into executive session to receive legal counsel.
I'll second that.
Does she have to revert?
No,
Okay.
No,
it's still,
we can stay
that's
right
the
Okay.
motion and second right now, just before we get to that.
Okay,
I'd like to,
executive session.
so we have a motion and a second,
second.
Yeah.
say all those in favor? All right, shall return shortly. Okay, so we will now end executive session. No action was taken. So currently, we have a motion and a second on the floor, so we can continue discussion right now. So does anybody have anything they'd like to add at this point?
I would just add that, that while I made the motion, I think for a good reason, I do think there are other avenues that could address this same issue in the form of a waiver, which we've, discussed a little bit here tonight. And I would encourage, if this motion passes, to look into that.
I would agree with that. With what we have before us, we're very limited in the choices that we have available, but a waiver process provides a lot more latitude for discussion and different options that could be used to resolve the situation.
And, I concur with all that. I also believe, too, that unless there was some other documentation provided, I'm still of the belief that it is one plat, one lot. If there were multiple lots, there were other avenues available to have those broken out, and since that has not been done, I don't feel like I have any other choice to uphold the staff decision at this point. But I do concur that there are other avenues available, and I would hope the appellant would explore those. So, motion and a second. Is there any other discussion? All right, all those in favor of the motion to uphold? Nobody? It's unanimous. So that ends that matter. So we move on to rezoning 24-21. Jonathan Caldwell, applicant owner, requesting to rezone a 3.0 acre portion of an 8.76 acre parcel from AGC to RUD. The subject parcel is located on Glen Road, Clover. The property is referenced as tax map number 376-0000060, Council District 2, Ms. Love. Hello, Diane.
Hello there. Good evening, everybody. This request here is to, as you mentioned, is to rezone a 3 acre portion of an 8.76 acre parcel from AGC to RUD. And the purpose this evening is to be able to subdivide the parcel to create 3 new lots. Parcel is located on Glen Road. It's in between the Ridge Road and Highway 157, just south of Clover. Zooming into the area here, it's still a relatively agricultural area, still some large lots, but there have been some subdivisions throughout the area here for less than the 5 acres. Zooming into the parcel, it's a very odd shaped parcel, and the intention here is to be able to subdivide to create at the most these 3 lots on that front of the parcel there. For the zoning for the area, the majority of this area is AGC, but there is some RUD to the south of here. The comprehensive plan for the area here shows it's to be rural residential. And as we know, that is areas that are rural in character with homes that are 1 acre or more. Typically, you don't have any sort of utilities there. There's a sparse road network. And it's surrounded by pastures and farms and forests. My staff recommends approval for this request. It aligns with the comprehensive plan and the future land use map. Any questions for staff?
Yeah, I got a question, Diane. So I know we're getting the denser, we're going down to 1 acre. With those 3 lots in front there, yeah, thank you. Do they have to have, and I always ask this question, do they have to add, or do they have any landscape requirements or buffering, special buffering requirements between those?
No, these would just be individual lots, not a subdivision, so therefore there's no buffer requirements or landscaping requirements for them.
Diane,
Thanks.
once the 3 lots are subdivided, the remaining tract that's left over, if that does not have sufficient road frontage, does that not create a non-conforming?
So we have measured it out, and we feel as though this here is sufficient enough to be able to be their road frontage.
Okay,
If that becomes short, I don't think it will, the property owner also owns this property right here. This is the applicant, he lives here as well. He
Okay.
could combine that to that piece of property if it falls short. And then if he, this is a rough sketch of 3 acres. If they cannot get 3 acres there, 3 lots, then it'll only be 2. But based upon a rough sketch, we think we can get 3 acres and have enough road frontage here to meet that requirement. But there's some alternatives if not.
Since Matt brought it up, what is that minimum distance that, for access? Do you know offhand?
For driveway access?
Yeah.
I don't know the minimum distance. I know there's a 100 feet requirement for road frontage for these lots, and they could meet that easily.
any other questions?
I had a question. Diane, was 062 originally part of that larger property,
062,
which is
The one
above,
right next to it.
above your number 1, which looks to be about the same size?
was that part of this?
Yeah, that's,
Was this one up here? At one point, I think there is a plat in your package. This was a much larger parcel that has been subdivided before.
okay.
So I think it may have been, I couldn't tell the actual plat itself, but I think it may have been part of that at some point. I don't know when the date was for this subdivision for this current tract.
I believe it was.
Okay.
Okay. Any other questions?
Is that a condition for it?
Are there conditions?
I don't think so.
I think there were any this-
Yes, there is.
Correct.
There would
So
be one
property
for
must be
motion.
survived, so
Yeah.
no more.
Right, the usual.
Yes.
I would like to make a motion to go into executive session to receive legal counsel, please.
We can do that. Is there a second?
I'll second.
All right, all those in favor of going into executive session? Okay, so we returned from executive session. No action was taken. So at this point right now, are there any questions for Diane? If not, can we have a motion? I go ahead and make a motion to recommend the rezoning to council.
I'll second.
Sorry, is that approval? Recommend what?
Correction, I would like to make a motion to recommend the rezoning to council with the condition as stated in staff report.
And I'll second.
So now, is there any discussion, anybody would like to say?
I just want to go on record here on this one. My concerns here are for spot zoning in this area. And I think that this can be used if this was to go through and be rezoned to RUD. I think that it can be used in the future to, again, expand the map and say, oh, well, this parcel is RUD, so we can do the next parcel in changing AGC to RUD. So I cannot support this.
Okay. I think also part of the consideration too is with a lot of the AGC land is for it to remain for those tracts that are used actively as farming to keep those. I think that's a huge consideration. I don't see there being any farming out here. Am I correct in that, Diane?
They probably have hay growing in pasture. That would be about it. Just utilizing the land they have there for hay, I'm assuming, just by the look of the aerials.
All right, so is there any other discussion? If not, all those in favor of the motion? Anyone opposed? And so the issue passes 4-2. All right, we move on. Rezoning 24-22, Roger Metz, applicant Christopher Adams, owner, requesting to rezone a 1.1 acre parcel from UD to GC. The subject parcel is located at 1670 Highway 160, Fort Mill. The property is referenced as tax map number 655-02-01-005, Council District 1, Mr. Audette.
This requested to rezone a 1.1 acre parcel from UD to GC, and the purpose here is to be able to expand the allowed uses to be more consistent with the zoning districts in the area. This property is located on the north side of 160. It's in between Pleasant Road and I-77 in the Fort Mill area. As you can see, this south part here, this is Baxter. Anything in that gray is the town of Fort Mill. With the 160 corridor through here is a commercial corridor here, mostly restaurants, retail, shopping. Zooming into the property here, the one that's highlighted in red, that's an existing building. They have mostly offices in there, and the applicant has a request to be able to go to GC for the personal services, and that would be to allow some kind of a hair salon to go into that property as well. That's the intention, but to be able to expand it to what you find in the area here for GC. Zoning for the area here is UD. I will highlight there's 2 parcels here at the intersection of 160 and Carolina Place that recently are going through the process right now to go to GC. So if those are successful, you'll have a little bit more GC in the area. Comprehensive plan for the area here is the town center. The town center is based upon the influence of the town of Baxter, influence that town center district, which is where you see things that are a blend of residential, retail, office, and civic uses within that area. Buildings are typically human scaled and designed for being auto-oriented, elements out of sight. We're recommending approval for this application here. It aligns with the comprehensive plan and the future land use map. It is similar with the development pattern for the area. There are other parcels, like I mentioned, also zoned GC, and it will remove one more UD parcel that's UD zone parcel. Any questions for staff?
there's no questions, is there a motion?
I make a motion to approve.
I'll second that. Is there any discussion? I'll just go on record saying, I know of the other parcels that we've recommended, they've also been zoned to GC, so this is just continuing that trend. It just really brings these into the current zoning. Removing the UD zoning is something that is
It's a good thing.
it's a good thing. It's on the list of things the county is wishing to get done, so another one coming off would be good, so. Is there any other discussion, anything else? All those in favor of the recommendation? Anyone opposed? Unanimous. Rezoning 24-23. York County Council has initiated the rezoning of 20 parcels within 16 multifamily communities from GCOI OR RMX 20 to the newly created RMX 6 zoning district, thus removing their non-conforming status.
All right. As he's familiar, we've had a few of these so far, different types of council-initiated rezonings, and those are a reflection of things we've done within RECODE. Right now, we are starting to rezone properties with council's approval to be able to put properties into this new RMX 6 district if they're an existing apartment or condominium or townhome. Right now, we're just focusing on some existing apartment complexes. There are 20 parcels, and that involves 16 separate multifamily communities. They are currently zoned either GC, OI, or RMX 20. We're looking at right now is council districts number 1 and 7, but eventually we'll go through the entire county. Once again, RMX 6 is that new district that allows multifamily. It was created by RECODE, and this action will also remove what became non-conforming status. Looking at the property here, the ones that are highlighted in this yellowy orange color within the Fort Mill community, there are, as I mentioned, there are 16 communities here within districts 1 and 7. Looking at district number 1 first, this is going to be on the west side of I-77, north of the river. And so in here we have the communities of Evolve, Palmetto, Bonnet Place, Stone Village, Millcrest, Legacy, and Bromley Village. These are all existing multifamily homes. Looking at the zoning, as you can tell here, this is a large mixture of zoning in this area here, but I'm highlighting that these are either going to be zoned MX20 or RMX20, or it's going to be GC. And then crossing over I-77 into district number 7, we're going to be rezoning here Millhouse, Beckett Farms, the Willows, the Commons, the Haven, and the Villas. And these are some older ones from the Regent Park area, Mulberry Village, Dogwood Hills, Woodridge, and Manor Lake. And these are all a combination of also RMX 20, and there are also parcels that are zoned GC and OI as well. For this, staff recommends approval of this request. Any questions for staff?
I do, and then I'll hit the discussion part when we get to it. But with redevelopment, especially in these older sections that you brought up, and I'm talking about District 7, because I'm not sure about your district, Kate. But redevelopment, is that going to be, are we going to put a good definition on redevelopment where there's a little bit of parameters of what you can redevelop and the extent of it to meet RMX 6?
I'm not too sure I understand the question about redevelopment. Could you be more specific?
Well, if we approve this, okay, are there going to be standards that they have to meet if they're going to be redeveloped? You know, height, height requirements, or is that just going to follow what we have existing right now for redevelopment?
They would go with the existing code. So by redevelopment, if I can go further, are you saying to remove, demolish,
Yes.
and redevelop? Or are
Right.
you saying?
Yeah, I'm saying remove.
So yes, if somebody was to come in through here and remove or demolish any of these developments, then yes, they would have to follow the existing code. So whatever that code would be right now, they would follow that one.
From an architecture standpoint, too.
from every standard of the code.
There's
For
everything-
height, dimensional, the whole thing, density, everything would go whatever the code says.
If they're doing something like just add an accessory building for like storage or something, they can,
They would still, they would follow the code in terms of setbacks and everything, so they would follow
Correct.
whatever the
There's-
RMX district setbacks are, they would have to do that.
there's certain, is it, I know with the
There-
building code, as you do more renovations, you have to do more to bring it up to code.
So we do have a threshold, and that's based upon your footprint. So if your footprint is expanding beyond a certain percentage of development, then you have to bring up the entire code to the site. Is that-
That's what,
is that you're
that's
getting
what I
at?
was asking.
So,
I'm glad
if
I'm
they,
getting
but
that.
if they were just to come in
Thank
and demolish and rebuild, it would be different. But if they wanted to add something, they would have to, they could go by the existing code up into a certain percentage, then they bring the entire site up to code.
Yeah. And I'll make a comment during the discussion.
Okay.
So, yeah, okay.
Is there any other questions for Diane? Is there a motion?
I'll make a motion to approve.
I'll second.
All right, is there any discussion?
Yeah, so my concern is in these older Dogwood Hills, Woodridge, Manor Lake, and Mulberry Village, they have character back, you know, and those were built many years ago. What I don't want to see is what's happening in Charlotte. It's been happening for years in Charlotte. They just build, they replace a smaller footprint home, and they put this big, and it's also apartments too, bigger footprint, and they're not meeting, to me, architectural requirements. And that's the concern. That's why I asked the question, because I don't want that to happen here. And I just wanted to point it out. I'd like it for it to be in the record that it's a concern of mine. That, especially the new, you know, or the old ones, the existing, the character of the neighborhood. So,
Would that fall within the architectural parameters?
It may, and they may even have things within their own covenants that were established many, many years ago that may limit the dimensions of that. They may
good point,
only
good
have-
point.
So there may be something already protecting those communities. I would imagine there would be. Something I
Okay.
can't say for certain, but I should imagine these
No, it's a
communities
good
have,
point.
have covenants
Yeah.
to protect all
I
that.
did, what you just said is perfect.
And I think also to remember that we're talking about a condominium as opposed to an apartment. So these are individual owners for each individual unit, as opposed to being an apartment complex. It'd be easier for somebody to come in and do something. It's a lot
Sure.
harder to change anything within that.
Right. But what you just brought out, that'd be nice to have in the record, that it should meet the,
We don't have
what's
any,
in there.
that's what they would do. You know, we don't, whatever the covenants are is what they can do. We would abide by that.
Okay.
So is there a way to differentiate apartments from condos?
Well, I don't know if it's RMX 6, if it goes to RMX 6, they could probably put anything that meets it, right?
Right, I would say the difference in what we're talking here for these condos, every other of these developments here are relatively new, and they're apartments. And there's only one other condominium project in the area here. I can't see them demolishing or changing the apartments, because they're already built out. They really don't have any spare room there. They've done what they possibly could on their land, so I don't see any big hardship there. I will say, as a relief, one thing I can point out for one of the applicants or one of the properties here, we were contacted a while back on a person who lives in, I think it was Stone Village, and he wanted to put a deck. It's one of those condominiums where they have ground level areas, and he couldn't put a deck on there because he's not zoned for it. This will allow him to be able to put his deck on.
Yeah, I
So
understand.
that's one of the benefits of
Sure.
putting this into a conforming district,
Yeah.
especially for the condos.
I just didn't want it to go the other
I
way.
understand.
All right, is there any other discussion? If not, motion to,
We're
To-
already in the motion.
We already had
To
one.
vote.
yeah, we had, I know, it was a motion and a second, so all those in favor to approve the motion, raise your hand. Opposed, none, it's unanimous. All right. Next item is rezoning 24-24. Zachary and Tracy Smith is the applicant owner, requesting to rezone a 3.77 acre parcel from RSF 40 to RUD. The subject parcel is located at 3310 Lincoln Road, York. The property is referenced as tax map number 386-00-00-005, Council District 2, Ms. Love.
So this is a request to rezone a parcel that is 3.77 acres from RSF 40 to RUD. And the purpose of the rezoning is to be able to allow the use that is animal production and livestock, that's keeping and raising. And just to let you know, this one currently is under code enforcement notice of violation for keeping and having livestock. So they do have chickens on the property right now. Property is located off of Lincoln Road. It's just south of Highway 55 and south of the town of Clover, kind of between Clover and York. This area here is still mostly agricultural, rural. There are a few neighborhoods to the south of here, and there have been some homesteads also within the area here, but it's still relatively rural and agricultural. The property here is a single-family home, and they do have some buildings here in the back of the property for, I'm assuming these are for the actual chickens and other utility buildings. This area here is zoned RSF 40, and there's kind of a swath through here that is RSF 40, but north of that is AGC, and there's also a little bit of RUD. The comprehensive plan for the area here is rural residential, which is more in keeping with how the property actually is utilized right now. And as you know, that's areas where you have a rural character, homes are 1 acre or more, you have pastures, fields, forests, and then typically have private well and septic and sparse road network. So we are recommending approval for this request here. It does align with the future land use map, the comprehensive plan. And while this area here, this is a very large area, like I mentioned, that's RSF 40, the area here is more of a rural character and agricultural uses. Any questions for staff?
No questions? Do we have a motion?
I'll make a motion to approve.
Second.
All right, is there any discussion? If there is no discussion, all those in favor of the recommendation? It's unanimous. All right. The next item on the agenda is rezoning 24-26. Daniel Moses, applicant, Daniel Moses, Homer Moses, and Joyce Moses, the owners, requesting to rezone 6 parcels totaling 9.25 acres from RSF 30 to RUD. The subject parcels are located on Johnson Road, Clover. The properties are referenced as tax map numbers 363-00-00-050, 363-00-00-053 through 057, Council District 2, Ms. Love.
The request here is to rezone 6 parcels totaling 9.25 acres from RSF 30 to RUD. And this is also to allow the use of animal production and livestock. This property here, just the one parcel, the 363-00-057, which is the main parcel, is currently under violation for keeping chickens on the property. Property is located off of Johnson Road, which actually is just within the town of Clover's sort of jurisdiction or area influence. It's just off of Highway 321, Filbert Highway, also becomes Main Street in Clover. Looking at the aerial here, everything in that gray is the town of Clover. This is an area, sort of a donut hole within that property. Next to it, to the west, is an industrial use. Highway, or 321, Filbert Highway, Main Street is the more commercial corridor going into Clover. There are homes within the area here as well, but there's also some commercial along Filbert. Zooming into the property here, like I mentioned, the one that's actually under violation is the furthest one down in the south, and that's where the chickens were here, and probably coming over to here as well. But this is all owned by the same family, and they wanted to go ahead and apply it all at one time to rezone it to RUD, to allow potential in the future, maybe some recombination, just go ahead and do it now for RUD. But as we mentioned here in the area here, there's an industrial site here, some light industrial to the north, some commercial, some garages along here, and then homes all throughout the properties south of that. Zoning for the area here, all the areas in this gray is UD. This property was zoned UD at one point. They did come in and get the property rezoned when we were doing our UD project. The gray area here is the town of Clover, but the other properties in the area here are RSF 30. The comprehensive plan for the area here is single-family residential. And as you know, that is where you have primarily single-family detached homes, lots that exist in more of a rural and suburban character, and they're meant to have a residential character within the area. Staff recommends denial for this request. It does not align with the future land use map and the comprehensive plan. It's located 1 block from Main Street. It's mostly surrounded by the town of Clover. And while it's not within a municipal infill designation, given the location, we did look to see what the town's plan recommends for the area. And the town calls this area here traditional residential, future land use. And that's going to be a mixture of low, medium, and high density residential. And the town actually even goes so far as to say they discourage uses that interfere with that residential character. And so because of the future land use map, the development of the part of the area, and what the town's vision for it as well, we don't think this area here is compatible with residential, commercial, and light industrial uses for these agricultural uses. Any questions for staff?
I just want to let everyone here know there are a number of emails that were forwarded to you this afternoon. If you were not able to read them, I have a copy here for you.
I got some, but weren't those for the first rezoning, Smith?
No, it's for this one.
It's for
It's
this
for
one.
this one.
Okay, sorry.
So, so currently they're raising chickens and anything else?
You know, I didn't see anything else. There's chickens there. I think there's probably some turkeys. There's some fowl.
Okay.
I didn't see any. There may be other animals there as well. I didn't see that. And then there's produce as well. But for most part, it's the chickens.
Is there,
I'm sorry, go ahead.
is there like a farmer's market that,
There is, I believe, occasionally a non-permitted farmer's market that happens there occasionally. I have not. It hasn't been a violation recorded, but I have heard of such thing.
Is the code enforcement, was that a complaint from someone that lives nearby?
I do not know. I believe it was anonymous.
Okay.
But it was a complaint.
There was a complaint. Yes.
So you said the town of Clover is, wanting this, or it's residential. Do they have any restriction on backyard chickens and such within their city code?
I don't know for certain. I'm going to think no. Typically, well, I don't know because Rock Hill does, so maybe, but I don't know for certain, so I can't speak to that.
Diane, so you had stated the area was originally zoned UD and now it's RSF 30. So were they one of the property owners that did the rezoning when it came through that part of the county?
Yes and
several
no.
years ago?
So the subject parcel where the property is right now, they were not part of that. I believe they came in before we were doing that. They wanted to build a house there. And at that point, it was a council-initiated rezoning to go to RSF 30 at that time. They didn't request RUD. I don't know why they didn't.
I was
But
going to
the
say,
rest of the properties here, they came forward with part of the UD project, and they were okay at that time with going to RSF 30. They approved that recommendation, and they moved forward with that, and that would have been in, I think it was 2019, maybe 18.
2019.
Okay.
Yeah, I think it was about that.
So a few years ago, they were okay with that district.
So were they told of the differences between the districts and what was allowed and not allowed?
I don't know how far the conversations go. When we were doing that project, we had public meetings to get the opportunity to come and speak to staff. And they were given a form and they were given a recommendation. Recommendation would be based upon the comprehensive plan, what's going on in the area, and they agreed to it.
So it's my understanding that this family's been on this property since 1961. Okay? 86 was the year that the county started zoning, and it was originally UD. And there's quite a bit of UD property surrounding this particular property that we're discussing. The applicant also owns property on the other side of Jefferson, which is not part of this request. But it sounds to me like in 2019, if they wanted to build a house on the first piece of property that we were discussing, it could have been rezoned RUD at that point,
Sure.
correct?
They could have. They could have requested that. I should say that. They could have requested that. I'm not saying it could have happened.
Okay,
I'm saying,
no,
yes, they had that
could have-
option.
They could have requested RUD, which
Absolutely.
would have allowed them to raise their chickens and do whatever they wanted. So would it make sense for someone that was already doing that to agree to go into a zoning code that wouldn't allow that use?
I'm fairly certain when the first property that came forward did not, it was vacant land, so it wasn't as though they were farming that land at the time. It was vacant so they could build a house. Now, they may have had some farming going on there at some point in the past numbers of, many, many years. When that came forward at the time, they didn't request anything for farming or say they wanted to do farming. So I can't say that they didn't ask for it, but they went to this other district. And I don't believe the other parcels, once again, there's a home here on this property here, there's a house here, and there's a house here. This property here has like a shop kind of thing over the back, and so this one just has a utility shed, and there's a house here. So there really isn't, if you're looking at that, you don't see farming going on through here. So if you were, other than what's going on this piece of property here, you wouldn't think this here is a farming community. And I don't know if it was a farming community back when it was requested for rezoning originally.
So, couple real quick. Each one of those pieces is more than an acre or more?
Yes, we have measured to make sure that if we're
Okay.
going to RED, they can meet their requirements,
Right.
and yes, they can.
Okay, and what are the differences in uses between, so we're at RSF,
RSF 30.
RSF 30, right? So are any animals allowed in RSF 30?
So in RSF 30, I believe you can have backyard chickens, and
Right.
so you could have up to 6 on a home, and
Okay.
in the Lake Riley overlay, you can even have a rooster. So that's what you could have, as a max.
Right, so that's 1, 2, 3, 4, 5, that's almost 40, right?
If
6
they
times
put
6,
them on,
yeah?
yeah.
If
If they
everything
put
was spread out and,
if they did
right?
that,
Okay.
But there has to be requirements too, in terms of they can't just be free range, they have to be
Un-
certain requirements and
Understood,
everything.
yeah,
So, you could
this
spread
was
them out.
something we went through last year where we defined how many
Yeah.
birds get to be birds and all that, right?
Right, but
Okay.
you cannot do a roadside market. So a seasonal roadside market is not allowed as a use in RSF 30.
Okay, and so if it changes to RUD,
Mhm.
where does the animal limit stop?
None,
There's none.
there's none.
So we could bring 1,000 cattle in there if we can shove
I
it
would
in the
assume with
backyard.
practice
and-
of farming, they would do what the land could achieve.
I understood, but I'm just, that's
That
part
could
of the, right? That's
part of the
because there's
decision.
no limit at all.
That's
We
correct.
have kind of a very restrictive,
Mhm.
and then we have wide open, and we don't have a lot of zonings that are in between those two,
Not for that.
which
Well,
is, which is what the challenge is sometimes, because we have folks that don't want to start a commercial farm, want to have a little bit more livestock than you would have as a pet owner, if you will, right? So we don't really have that delineation in our code, right? You're either a lot or you have this very restricted amount. Am I understanding
That's
it
correct.
correctly?
The
Okay.
code settled on being 6 as being the number that you could have. And then after that, it's when you're on RED or AGC, it's unlimited. There's
Okay,
no in between.
okay.
Dan, if I might, what were the requirements on UD with the allowable?
I would have to go back and look at the code to see if it allowed that at the time. It may have at one point allowed it, but I can't say for certain what if UD allowed raising of animals.
And the roadside market is permitted in RUD.
With approvals, yes, correct. It's an allowed use.
You said it isn't allowed use?
It is.
Is it-
It's an allowed use, it's an allowed temporary use in RUD
Okay.
with staff approvals.
Actually permitted or staff, how does that work?
They would have to come in and, I think there's an application process. We don't do it that often. And so, but there is an application process for that to establish areas for, parking and things and that kind of stuff. But there is a process for that.
Matt, can I make a motion? Or is there any-
Yeah, just, Mike is looking through the code right now, I just want to make
Okay,
sure.
great.
Yeah, just So is that, the roadside market, is that a exception, or is it permitted use period, or?
It's an allowed use, it's a temporary use, in that district. It's seasonal roadside market, I believe it's called.
Let me see if I can find it. Aha, here we go. Okay,
Yep.
yep, all, okay.
Says T,
T,
temporary.
temporary.
Subs, part 5, for all of the temporary stuff that
Right,
could
so they'll be
happen
in that subchapter requirements for them to meet.
Okay, thank you.
So every time the landowner would want to have a market or a roadside sale or whatever, they would have to be permitted each time?
No, I believe it's set up in terms of its number of months, so it's a seasonal one, so you can have it for a season. And I would have to look at the code, I don't remember exactly how many months it is, but I think it's a couple times, in 2 groups of seasons, but there is requirements for that.
Could be some designated repeatable times. Okay.
Thanks, Mike. This to me is kind of like, the property owners preceded much of what is around them. It's kind of like building an airport at the outskirts of the city and then having that infill and then people complaining about noise. If you look at the adjoining properties, I'm assuming that all these people that are still UD zoned were also given the opportunity to rezone at some time.
Correct.
2019. The majority of them look like they chose not to, for whatever reason. So I would like to make a motion to allow the change over to RUD in zoning so that the how many year old property can continue to work the way it was always done. It's not in the city of Clover. It doesn't look like Clover has any jurisdiction over that. That's probably a good thing. But my motion would be to allow the rezoning to RUD.
I second.
There will be a motion to approve.
Yes.
Yeah.
Is there any discussion? I'll just like to add, although it's not required here, I would like to just speak to the audience and get a poll from them to see who's here in support of it tonight. Can you all raise your?
That's what we thought.
Yeah.
I think this is a huge benefit to the community.
Yes.
I do too.
And so I'm definitely in support of the rezoning.
And I certainly understand all of the issues here. While it is not consistent with the comp plan, future land use plan, I do think in certain instances, we can deviate from that. One of the reasons I will vote in favor of this is because this is an existing farm. Most of this has predated county zoning. I think that's considerable fact in this, and that's one of the reasons why I would like to do it. I would not be in favor of somebody proposing a new farm in this area at the time, but something that's already been there in the community for years, I think should be allowed to continue.
Yeah.
So, is there any other discussion?
Yeah, I just want to make a comment. My grandparents were farmers many years during the Depression when it came up in '29. So I love this. And this is the sign of the times. We're going to have to go back to this. I will tell you. So I applaud you all for coming in here.
Yes, thank you for coming out here today.
Yeah, and I'd like to add that this is some of the challenge that we face, as I kind of brought up. We kind of have the two extremes, and I'd say as discussions go on with what things we might think about doing different in the code, I would really like to see us having some intermediate type designations put in there that would allow folks to do something more than what you might consider backyard pets, but maybe not get as big as full farming and everything wide open and any animals and as many animals as you want, that might help fit these situations a little better for us. And the other thing is, whoever is the parent of that young lady right there, you are doing an outstanding job, because she has been very well behaved through a very, very long meeting, so keep up the good work.
All right, is there any other discussion?
No, I think we're good.
All right, all those in favor of the motion? It's unanimous. All right, so we have the rezoning tracking sheet. It's left here.
No changes, welcome.
Anybody have any questions about anything?
Nope.
All right, if not, then we're at the final item. So is there a motion to adjourn?
Motion to adjourn.
Is there a second? All those in favor? We are adjourned.
Thank you, everyone, for coming in.